SRIRAM's IS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello students, welcome to SRIRAM's IS. Welcome to this concept class which we have started for your upcoming prelims examination. This will help you a lot. I am Mayank Bharadwaj presenting you this polity concept class, and this is class number 7. We have already covered 6 topics before that. Okay, prohibition of discrimination. This is the concept which we are going to learn today. What is prohibition of discrimination? So we see in India there are discrimination on several grounds. The society was divided because of the evolution of the society from so many thousands of years. There were sections created which became the basis of discrimination in the society. Such bases were religion, race, caste, which became a very big dividing factor in the society, especially within the Hindu religion, place of birth, and of course the gender of a person, the sexual orientation of the person. All these things have become the dividing factor, the rift in the society, and inequality was created. Now when the constitution makers were making the constitution, they wanted to ensure that any discrimination by the state on all these grounds must be prohibited. The state shall not discriminate anyone, the citizens of India, on the basis of religion, race, caste, sex and place of birth. And that is the origin of article number 15. Article number 14 we have already seen is equality before law and equal protection of law. It tries to establish equality in the society that is open to all. That simply means to citizens and to non-citizens. This applies to all. That right under article 14 is extended to all the people who are there in the territory of India, but article 15 is specifically for citizens. What article 15 does is it particularizes article 14. Article 14 is a broader concept of equality, that there shall be equality before law and equal protection of law. We have already seen that concept in the previous class. What do we mean by equality before law and equal protection of law? Now article 15 is particularizing it. That simply means article 15 is providing several grounds on which the discrimination must be prohibited. The state must not do discrimination on several grounds, and those grounds are religion, race, caste, sex and place of birth. Specifically it is writing these grounds: religion, race, caste, sex and place of birth, or any of them. Okay, that a person, we will see in detail what these terms mean here. So article 14 is a bigger concept and article 15 is a smaller concept within article 14. It is particularizing article 14. Article 15 particularizes it. Now when I say particularizes it, it simply means that it gives you a specific direction where the prohibition of discrimination has to happen. Okay, I hope you have understood. So this is the broader concept, article 14, and this is the particular concept of article 15, which provides the grounds on which prohibition shall not be done by the state. So what is this term religion? We all know there are several religions in India, and India is a secular country. It respects all the religion, protects all the religion. State does not have the religion, but there shall not be any kind of discrimination based on religion. So what does it say? It means that no person should be discriminated against on the basis of religion from accessing any public place. Okay, that a person of a particular religion is prohibited to go to a particular place like well, like ghats, like public restaurants, like cinema halls. This must not be done. Okay, public places which are open to all, like parks, like the other monument sites everywhere in the country, they are open to all and they are for general public, and no discrimination shall be made on the basis of religion. Any policy made by the government, the policy must apply to all and benefit all the people in the country. It should not be made for a particular section of a particular religion. That kind of discrimination is also prohibited. And any other group. Yeah. So any policy made or any public place, nobody shall be discriminated on the basis of religion. Similarly, on the basis of race, caste, sex and place of birth. Like ethnic origins, if a person is of let's say Afghan origin, example is also given, a person is of Afghan origin should not be discriminated from the people of the Indian origin or the Dravidian origin. That shall not become the basis of discrimination, because there are many and many Afghan origin people who are living in India and their forefathers have been living in India and they are very much citizens of India. Just on the basis of race, you cannot discriminate somebody. Okay, caste has been a big dividing factor. There were several socially and educationally backward castes in India. Similarly, there were tribes in India which to a very large amount of time could not come to the mainstream society, and that is the reason why the scheduled castes, also several castes like scheduled castes were listed and special provisions were made for them so that they can be brought into the mainstream society and equality can be created in the society. So caste shall not be any discriminating factor and state has no authority to discriminate anyone on the basis of caste. So discrimination on the basis of caste is also prohibited to prevent atrocities towards the lower caste by the upper caste. This has happened in pre-constitutional era and unfortunately has also continued in the post-constitutional era. That means after the commencement of the constitution, although there are constitutional provision to protect statutory provisions like SC/ST Prohibition of Discrimination Act of 1989 which protect the lower castes, but still that social aspect and the thing which are very deeply ingrained in the Indian society is not going away. This caste discrimination is still there, but state must not discriminate on the basis of caste. Now that is an important element here. Okay, the state must not discriminate anybody on the basis of caste. Now how can state discriminate? While making law, while executing law, while making any policy of the government, it can favor some caste or put obligations on other caste. That should not happen. The resources of the country must be equitably distributed and every caste should be equal in front of law. On the basis of sex, gender has been male and female. We have seen in the history females have been discriminated largely, and now there are several movements going on from many decades for the upliftment of women, and still that is happening. It's a continuous process which is happening, and state shall not discriminate anybody on the basis of sex, and the same goes for place of birth. Okay, now if you see this specifically, it is written in clause number 2 of article number 15. Clause 1 says that there shall not be any discrimination on the basis of religion, race, caste, sex and place of birth. What does clause 2 says? It has pinpointed that there shall not be any kind of disability or liability or restriction on the basis of religion, race, caste, sex or place of birth for the access to shops, public restaurants, hotels, places of public entertainment, use of wells, tanks, bathing ghats, roads, places of public resort, maintained wholly or partially by the state. So it has pinpointedly written several places and the access to it are for all, and that access must not be restricted to a particular caste or religion or people of particular origin of a particular sex. That is the reason why it became a big issue when women were prohibited from entering temples and dargahs. this is one of the article which was infringed. Okay, I hope you're getting the point. This is clause number 2, and now there are exceptions. So first thing for us to understand in this concept is there shall not be any kind of discrimination, and the bases are given. The bases are religion, race, caste, sex and place of birth. This is first thing we have understood. Now there are also exception given, because in our society brute equality cannot be practiced. Equality before law is a good concept, but it has to be accompanied by equal protection of law. That simply means some affirmative actions are needed for several sections of the society to uplift them and bring them to the level of other people, and that is the reason why several special provisions can be made by the state. This is an exception given to article number 15, which is also written in article 15. The exception is, this is clause number 2, and clause number 3 says that nothing in this article, that simply means article number 15, shall prevent the state from making any special provisions for women and children. For example, it makes a policy for women and give reservations to women. Nobody should come up and say that article 15 prohibits the state from making any discrimination on the basis of gender or sex, because the state is empowered to make special provision for women and children for their upliftment, for their empowerment. Okay. Now these 3 clauses were there in the original constitution, but there were other classes also, there were other sections also which needed special provisions for their upliftment, and that is the reason why several changes has been made as the constitution started to progress and the country started to progress. And the first Amendment Act of 1951 has extended this particular article 15 clause number 3, and it has extended to include scheduled castes, scheduled tribes and socially and educationally backward castes. And it says that special provision can also be made for these particular sections of the society. So that is exception number 2. Exception number 1 was that special provisions can be made for women and for children. Exception number 2 is special provisions can be made for SC, ST and other educationally and socially backward classes. So okay, there are 2 exceptions we have seen. State can make special provision for the advancement of socially and educationally backward classes of citizen and for the scheduled caste and the scheduled tribe. Those are the affirmative actions. Special provisions helps these sections of the people to come up in the mainstream. It helps the society to become more equitable and equal. These are very important provisions given in the Constitution of India, which gives the authority to the state to make special provision to help the society to become equal, because not necessarily all the sections were equally empowered when during the commencement of the Constitution. In 1950, there were great divides in the country, and there were, as we have already seen, that there were several grounds on which people were discriminated all around, on the basis of religion, on the basis of caste, on the basis of origin, on the basis of sex. So the prohibition of discrimination needed to be done, but at the same time, those who were left behind needed to be brought in front, and for that special provision is very much required, and hence the Constitution extended by the First Amendment Act extended these special provisions to SC, ST and socially and educationally backward classes also. Now several other things also happened. There were actually Article 15 have 1, 2 and 3 clause. These 3 clauses were present in the original Constitution. Okay, and then other clauses were added by several amendments. For example, clause number 4. This was added by the first Constitutional Amendment Act in 1951. Then came clause number 5th. Okay, this was added by the 93rd Constitutional Amendment Act in 2005. At that point, right to education became a very important issue. It has also become a fundamental right under Article 21A, and for that reason a special provision has also been made for the scheduled caste, scheduled tribe and socially and educationally backward caste for their admission or their enrollment into the educational institution, whether aided by the government, not aided by the government, whether public institution or private institution. But any person of the community, these community, scheduled socially and educationally disadvantaged section, as well as the scheduled caste and scheduled tribe, if they need admission in the educational institution, that is provided by the state. Now the educational institutions can be the state run institutions or can be private institutions. They both can be aided by the government or not aided by the government. So in a way, if you see in all the educational institution except the minority educational institution, this special provision provides admission to the children of SC, ST and socially and educationally backward classes into the educational institutions. This was a very important amendment made which introduced clause number 5 in the article number 15 of the constitution. It is very important for the upliftment, because until and unless you give education to these classes, how they are going to come up? They will perpetually be backward. If you do not provide them education, if you do not educate their children, they will keep continuing the kind of work they were doing from centuries if they are not educated. So education is one of the most important element to bring equality in the society, and all the sections of the society which were unequal or which were treated unequally or which were sort of backward and which were not in the mainstream, if their children gets education and proper education, there is a very good chance for them to uplift themselves, empower themselves and come into the mainstream society and compete with other sections of the society who are developed sections of the society. I hope you are getting, and that is the reason why in 2005 this particular 93rd amendment has brought or inserted clause 5 in article 15 of the constitution, providing admission to SC, ST and OBC in the educational institutions. I hope you got it. And the third amendment was made in order to introduce clause number 6. This was done in 103rd Constitutional Amendment Act. It is again a very important insertion in article number 15, clause number 6, which tells that any section of the society other than SC, ST, socially and educationally backward classes, these are 3 sections, any section other than these which are economically weaker section, that simply means even in the unreserved category, if there is a category of economically weaker section, then those people can also be benefited by government actions. Special provisions can also be made for economically weaker section. This was brought in 2019 by the present government, which is still continuing after 2019. Okay, it's continuing its 3rd term. So state can make special provision for the advancement of economically weaker section of citizen other than SC, ST and OBCs. I hope you get it. Now, state can make special provision for the advancement of these sections, economically weaker section, when it pertains to their admission in educational institutions. Now, educational institutions can be public run or private run, can be funded by the government, wholly or partially, aided by the government or not aided by the government. All the educational institution must admit economically weaker section, and if any reservation is provided to economically weaker sections, that is provided over and above to the reservation which is already provided to these sections, over and above this. Okay, and that must not be more than 10%. That must not be more than 10%. So the limit which was set by the Supreme Court, that the reservation must not go beyond 50%, was for these sections. Now for economically weaker sections, additional 10% reservation can be provided. Okay, maximum 10% of the total seat. So I hope you have understood this concept of prohibition of discrimination and the exceptions provided in article number 15, which empowers the state to make special provision for women, special provision for children, special provision for SCs, for STs, for socially and educationally backward classes, for their admission into educational institutions, private institutions or government aided or not aided, does not matter, but their admission into educational institutions. Also special provisions can be made for economically weaker sections other than SC, ST and socially and economically weaker sections. So this was the concept. I hope you have understood this and this will help you a lot in your upcoming examination. Thank you very much for attending this class, and we will meet in the next class, in the next lecture of the concept classes series. Thank you.